Good morning, Sir James.
Well, timings, first of all.
Yes.
We're having a think about timings. We're not sure at the moment whether we're sitting all day today.
No. Well, I think the position is this, Sir James. I don't know what you've agreed amongst yourselves, but this is obviously an important case.
Yes.
And we do not want to rush the parties, and there is no possibility of extending the court days or sitting after the end of the court day at 4:15 tomorrow. And so basically we want to hear full argument on this case.
Yeah.
And we want to be taken to the relevant authorities.
Yeah.
And we do not want you to canter through and pretend that we know everything that we may or may not know.
Understood, yeah.
And in those circumstances, it seems, at least to me, sensible to use this afternoon out of an abundance of caution.
Although I respectfully agree, and that may mean it extends to today and tomorrow.
So we would be expecting to sit for 2 days.
Yes.
And I'm afraid convenience of counsel is, I'm afraid, not something we can take into account. So, Mr. Hussain, are you happy with that?
My Lord, yes. Thank you very much for entertaining the request. No disrespect was.
No, I mean, I quite understand, but
Mr.
unfortunately,
Kiriko's
sometimes the courts need to hear full and proper argument about an important matter, trumps even counsel's availability.
No, it's in fact very helpful to have the time.
Okay, well, Sir James, on you go.
Well, ultimately, I'm grateful. You have the cast list. I wasn't proposing to go through that again.
No, thank you.
By way of introduction, a very brief introduction, the background to this case, as you will appreciate, is is set out in our skeleton for the purpose of the hearing. And I hope you've had a perfected version of that with all the relevant references in. Notionally, it's dated the 19th of June, but skeleton paragraph 1 and paragraphs 4 to 9 at the core bundle, tab 4, page 38 and 39, give you the core background. In brief, the respondents to this appeal are Palestinian residents of Gaza, comprising a husband, a wife and 3 children. They applied for entry clearance outside the immigration rules, asserting an Article 8 right to enter the United Kingdom, and were refused. See for that the FTT decision, just by way of example, paragraph 1, core tab 9, page 139. The essence of the application was, as the FTT put it in paragraph 7 of their decision, page 140 of the core, that the first appellant has family life, that's the father, the first appellant, has family life with a brother in the United Kingdom who wishes to sponsor the appellant to join him in the UK, and that the remaining appellants, that's the wife and the 3 children, have, quote, a degree of family life with the sponsor by association. So it was put accurately, we respectfully submit, by the FTT, para 7. The entry clearance officer refused the applications in the case of each respondent in materially identical terms. You have those in the core bundle behind tab 19 at page 212 and following. Again, in brief, the respondents had applied using the Ukrainian resettlement scheme as their pro forma, as it were, but as a matter of substance, their applications constituted human rights claims for the purpose of Section 82 of the Nationality, Immigration and Asylum Act 2002, so there was a right of appeal. If needed, there was a preliminary FTT decision analysing that procedural position, which is in the core bundle at tab 8, page 133, see in particular paras 17 to 25 of that preliminary FTT decision, not controversial in this appeal. The FTT considered the appeal and gave a decision on the 11th of September 2024. I've already given you that reference in the core, it's core tab 9. In summary, they found that Article 8.1 family life existed between the sponsor, I'm going to call him the sponsor or the sponsor or brother, and the first respondent, that is the father, and by extension, and we saw by association, the remaining respondents. So family life existed, find the FTT, but they found that the refusal of entry clearance was nonetheless proportionate and justified under Article 8.2. The respondents appealed to the Upper Tribunal. The Upper Tribunal decision is at core tab 7. In summary, they upheld the finding on Article 8.1 family life, that's paragraphs 40 to 58 of the Upper Tribunal decision, but they overturned the FTT's proportionality analysis on the basis of errors in the reasoning of the FTT as they found them to be, and they then remade the proportionality decision themselves and found that the refusal of entry clearance was disproportionate. Following that decision, there were various kerfuffles about appealing to this court, and ultimately what happened was that the respondents themselves have been permitted to enter the UK in the aftermath of the UT decision, but this appeal proceeds because it raises issues of general and particular importance. Three important aspects, perhaps, to the case, which are framed in the three broad grounds that I'm going to address you on. What qualifies as Article 8 family life when one is dealing with adult siblings outside the core family unit? 1. 2. Whether individuals outside of the jurisdiction of the United Kingdom for Article A1 ECHR purposes, nonetheless themselves in some way have rights under Article 8. So who's the right holder, if you will? And thirdly, the proper approach in a case like this to assessing whether any interference with Article 8 ECHR is justified in the light of the importance of immigration control, particularly in cases where one or more individuals within the family, and we only get to this issue if there's family life in the relevant sense I've indicated, where one or more individuals of the family are in a war zone or are in a zone where they are facing conditions of extreme difficulty. And I deliberately extend that logic out. It's an A2, A3 worry about the conditions in the foreign state, be they created by armed conflict or some other set of conditions in that foreign state.
James, can I just put down a marker, please? Because you referred to an interference with Article 8. This isn't a case, I don't think, from what I've read, where the Secretary of State is positively interfering with anyone's right. Isn't it a case where what is relied on is a positive obligation? But I think it may be important to keep that distinction.
My lady, yes. I'm sorry, I used the language loosely, as it were. Of course, there is that question as to whether or not you're dealing with a negative or a positive obligation, and here we're undoubtedly dealing with the positive because it involves an assertion that Article 8 required a positive step to be taken, namely the permitting of entry. I mean, ultimately, the case law doesn't draw very sharp distinctions between those two things.
Well, if you get to the proportionality analysis.
It becomes important to see whether you're triggering the positive right.
Yeah.
My lady, yes, I'm grateful for that clarification or correction. I was going to turn immediately, if I may, to ground 1, the existence of family life. We've dealt with that in our skeleton paragraphs 10 to 26. I'm assuming you have them loose, but if you want the skeleton references, ours is in the core bundle at tab 4, page 39 to 45 for relevant purposes.
But you don't need to keep on giving the core bundle reference. Just the paragraph in the skeleton is enough, I think, for all of us.
I'm grateful. Yeah. That will speed things up a bit, make them less clunky. I wanted to give an overview of what our submission is going to be and then develop it by reference to the case law, if I may. As I said earlier, this issue concerns the test that applies outside the core unit of parents and children, parents and minor children. So we're outside that bubble, as it were. In the present case, the relevant relationship on which we're focusing is in essence between two adult siblings, the father and the brother who is in the United Kingdom and is the sponsor, and also between one of those siblings, that is the brother, and the wife and the children of the core family unit. My fundamental submission in 4 short propositions is this. Firstly, we say, in order to establish the existence of family life for the purposes of Article 8, beyond parents and their minor children, you need to demonstrate dependency. That's the word, dependency, and not simply support. Secondly, it is dependency.
We'll just take this slowly, can you?
Yes.
You need to demonstrate
Dependency and not simply support.
We're going to have to look at what those mean.
We are.
That's first point. Second point?
Second point, it is dependency in the ordinary and natural meaning of that word. And we submit that the European Court of Human Rights cases indicate the rigour, height and true meaning of that concept. I'll come to the case law in some detail, but one of the phrases that repeatedly appears in the Strasbourg case law is that one person is, quote, compelled to rely upon the other in their daily life.
Is the quote in their daily life?
I think so, but I've only got it in my notes around compelled to rely. We'll come to it and I'll flag it.
Well, it's pretty important, isn't it? Yeah. 3.
3, dependency is crucial. Various categories of support for family members will fall within the ambit, which sits on the other side of this distinction or divide, will fall within the ambit of normal emotional ties. Normal emotional ties fall on the other side of the line. Not enough. Something more is needed. Dependency is what is needed, we submit. And the fourth and final submission, they will elide a bit, I'm afraid, but the fourth and final submission is that dependency is and imposes a fundamentally different and more exacting standard than the test for which the respondents contend, which is, as they put it, quote, real and committed support.
Well, that comes from the Lady Chief Justice's judgment, doesn't it?
Yeah, it does. Mobeen, which I'll come to.
Mobeen, yes.
It can be traced back to Lord Justice Sedley, but I'll show
Right.
you the case law. Those are the 4 propositions, and we say that the dependency test, as I've described it, is the right one for this court to apply and to adopt for 3 main reasons. There is a clear and consistent line, we submit, of European Court Strasbourg authority, starting in S and the UK, I'm going to take you to these cases, in 1984, and continuing through with clarification to the most recent decisions in Demirci and Hungary and Kumari. Kumari in particular providing a clear and important summary of the relevant Strasbourg case law and a review, a deliberate review, a careful review of the general principles to that effect. So there's a clear and consistent line we submit. Secondly, we submit in relation to domestic authority that it, including Beku Betts in the House of Lords, expressly endorses that test of dependency. And to the extent that Lord Justice Sedley and Kugathas is properly to be read as having diluted the threshold from dependency to support, that was a wrong step and evidently cannot survive the later explanations and analysis, even if it could survive the earlier Strasbourg case law, the later explanations and analysis in the Strasbourg case law. So that's the second point. There is consistency, properly analysed, subject perhaps to that in the domestic authorities. And the third reason of principle is the AB reason, that is the Queen, AB, and the Secretary of State for Justice, which I know the court will be very familiar with. That was the case in which the Supreme Court revisited the Ulla principles about how the domestic courts needed to approach the Strasbourg case law. And the conclusion of the Supreme Court, having deliberately gone down the road of looking at that set of principles all over again and analysing the underpinning for them and so on, arrived at a test which required the domestic court, in applying the Human Rights Act, to be, quote, fully confident, and I use that phrase deliberately because it's used twice in the relevant paragraph of the Supreme Court's judgment in AB, to be fully confident that the European Court of Human Rights would go to the principal place which is asserted. In other words, here, you need to be fully confident that the Strasbourg court would equate dependency, in effect, with mere support and find family life in the present case or equivalent cases.
James, may I ask you a question about your second proposition? As a matter of domestic precedent, is this court bound by what Lord Justice Sedley said in Kugathas? I can't remember whether his was a judgment with which the other members of the court agreed or not.
It wasn't. My lady, I'm going to take you to...
All right, that's helpful. Thank you.
There's a question about... It wasn't.
It wasn't.
There's a question about whether or not even he decided that, as it were, but I'm going to take you to that
Okay,
case.
that's very helpful.
It's a fair question.
Well, sorry to sort of...
No, the answer to your question is it
Too
wasn't.
soon.
And if we're looking at whether we're bound to, what is the status of Morbeen?
My lord, you would in theory be bound by Morbeen, but again, I'll come to that if I may and analyse what it truly did and didn't decide.
Thank you.
The difficulty that you've got to some extent is that if Strasbourg, that's why I introduced the third proposition about AB, because if the Strasbourg case law has developed, and we say that there's at the very least been a strong clarification in Kumari and those later cases, then we know that the position in principle in relation to precedent is the one set out, I think, by the Supreme Court in RJM, which is that if the Strasbourg case law has moved on, the Court of Appeal can reach its own conclusions and bring the domestic case law in line, even in the face of what would otherwise be a domestically binding precedent at this level.
Thank you.
So I wanted to start, if I may, by analysing the Strasbourg case law, which we say is clear and consistent. And the first case to go to invite the court to go to, if I may, is the S and the UK case, a decision of the European Commission on Human Rights. That's behind tab 36. In the bundle of authorities. Page 895. I'm sorry, mine's on temporarily able. Can I just get another copy? Yeah, I have it. Sorry, I have it. I just didn't have the tab. So 895 is S in the United Kingdom. And you see the facts at 895 to 896. Can I just invite you to cast an eye down the bottom of the last paragraph on 895 over the page to the bottom of 896, you'll get the flavour of it. So in summary, as you see, the applicants there were Indian mother and son. The son was settled in the UK, had been settled in the UK since 1974. The mother had been granted entry to join the son in December 1975. They then go back to India for the son's marriage. They sell the family home and invest the proceeds, and the mother is then refused permission in 1979 to rejoin the son, brackets in England, quote, as the entry clearance officer was not satisfied that she was wholly or mainly dependent on him. That decision was upheld by the adjudicator, who noted that there was a strong emotional dependence. You see that phrase used about 6 lines up from the bottom of the first long paragraph on page 896. You see the quoted, a strong emotional dependence. Thereafter, the mother developed depression and anxiety, and mental health deteriorated as she was separated from her son, a fact that was medically certified. The Commission, nonetheless, found the complaint to be manifestly ill-founded. And you see that from their reasoning, which is short, and it's at 897, just by the second notional hole punch, physical hole punch if you're on hard copy. The Commission refers, can I just invite you to read those 4 paragraphs?
We're going over to 898.
My Lord, if you would, just to see, it's only a couple of paragraphs.
Yeah.
And so you'll see the emphasis in that final paragraph on 897. I've put a little circle, as it were, around dependence, cohabiting dependence in the 5th line of that paragraph beginning, however. Generally, the protection of family life under Article 8 involves cohabiting dependents, such as parents and their dependent minor children. Whether it extends to other relationships depends on the circumstances. Relationships between adults, a mother and a 33-year-old son in the present case, not necessarily acquire the protection of Article 8, without evidence of further elements of dependency involving more than normal emotional ties. That's the mantra that gets repeated and that gets clarified as the case law goes on. But it's that concept of dependency which underpins it. And it's clear from that passage that the test is concerned with the identification of dependence and elements, in the plural, of dependency. And that concept of dependency is contrasted with and involves more than normal emotional ties. So it's the element of dependency that needs to be established. That's the threshold. There's no suggestion that some support would be enough to meet that threshold, or that some emotional, even emotional dependency is sufficient. And one sees that because of the way in which the thing was applied. That principle and test was applied in that case. The mother had substantial links with India, where she lived most of her life, and the court concluded that it hadn't been shown that she is financially, I'll come back to financially in a bit, but financially or otherwise materially dependent on the second applicant. And that was despite all of the findings that had been made and all of the facts that they'd set out at 896, including, no doubt, as they put it, a strong emotional dependence, the existence of deterioration in mental health because she is away from her son, and a recommendation from the certifying doctor that she should be allowed to rejoin her son, but she wasn't responding to medical treatment for that depression. And we submit that that dependency formulation, contrasted with normal emotional ties, and we say evidently different from the mere idea of support, or real and committed support, starts here and is then taken through and clearly and consistently applied in the Strasbourg case law since then. I emphasise this is all outside the paradigm case of parents and minor children. We're dealing with the connections when the assertive relationship is between, principally or fundamentally between the adults, as it were. And I wanted to go to 5 cases to make that good, clear and consistent application. The first of them, in terms of time, is the A.W. Khan and the United Kingdom case. Now, that was one of, I'm afraid that's the only new authority that you've been sent. I'm rather hoping that the Master of the Rolls has had that electronically.
I have.
Direct. You've got that electronically, and the others I hope will have it in hard copy. And electronically, thank you. So A.W. Khan first.
Is this in chronological order we're taking these cases?
Yes, it is. This one is 12th of January 2010.
Thank you.
And one can take the facts, I suspect, so far as they're of interest, from paragraph, this was a deportation order case, but matters not for present purposes, we're looking at the relationships in question. Can I take the facts from paragraph 9 on page 2, page numbering in this case on the top corners of the pages. So para 9, if you would, first of all.
A removal case.
It's a removal case, my lord, as you see from paragraph 7 and 8 that precede that. They've got all of his immediate family here, mother and siblings here. They're all in poor health. He was the main person who kept the house clean. Mother had diabetes and a heart condition. Siblings suffered from the ailments that you see there, asthma and eczema. And he suffered from his own illnesses or medical conditions for which he was receiving treatment in the United Kingdom. You see how the case is put on his behalf. And again, it's to some extent a repetition of the facts that you see in paragraph 9, but look at paragraph 25 on page 5, if you would. And then for present purposes, the paragraph I want, which relates to the family life issue, if you finish with 25,
yeah,
is 32 on page 7.
yes.
So my lord, the Master of the Rolls, put to me, it all depends what we're talking about. It all depends what it means. This is, as it were, the start of the clarification journey as to what that means. The mantra, the headline mantra, may remain the same, as it were. Strong, you demonstrate additional elements of dependence. The word used is constant. It's dependence. The question is, what does that mean? We know it doesn't mean normal emotional ties. What more does it mean? You get the first sort of indication from this case. The number of different health complaints doesn't constitute, quote, a sufficient degree of independence to result in the existence of family life. And in part, dependence, and in part the reason for that is because, look at the final sentence, it does not therefore, the court does not therefore accept that the applicant is necessarily the sole carer That's the sort of dependence one's talking about. No one else can do it. The sole carer for his mother and brothers. And by the way, look at the medical condition. They do undoubtedly suffer from health complaints. About the final sentence of 32, there's no evidence before the court that would suggest that these conditions are so severe as to entirely incapacitate them. They're looking for a relationship which involves that caring degree of independence. The nature of dependence is caring, and the person who is to be cared for would appear to have to be almost entirely, if not entirely, incapacitated to require that dependence to be made good. That's A.W. Kahn. Bielski and Poland is the second one. That's at tab 58, page 1575. 1575. This is the 22nd of October 2022. The decision of the court.
Sorry, 157.
1575. Does that take you to Bielski and Poland?
Yep.
And can I invite you just to read the head note for the facts? So 1575. So in summary, the applicant was the biological father of DB who had Down syndrome and lacked capacity. Relevantly, the claim related to periods in which the son was an adult, so this was a case in the territory of parent and adult child, see paragraph 46 in the judgment, which we'll come to in due course. DB's mother, A.R., was appointed his guardian, and she prevented the applicant from seeing his son. And under Polish law, there was no power to regulate contact between the applicant and his son in circumstances in which the son already had a legal guardian, namely the mother. So the applicant, that is the biological father, brought the claim under Article 8. If you go forward in the judgment after the parties' submissions are summarised, page 1582, you will see a section in the court's judgment in which they summarise the applicable general principles. That's the title above paragraph 39. And just to spin through those very briefly, you will see that in 39, the court reiterates, unsurprisingly, that the existence of family life is a question of fact, depending upon the existence of close personal ties. But the remainder of those principles are then devoted to the question, what is the correct principled approach? And what constitute those close personal ties in circumstances where you're dealing with the relationship between adults. So paragraph 40 is perhaps of particular importance here. The court further reiterates, as you see, the principle that relationships between parents and adult children do not fall within the protective scope of Article 8 unless additional elements of dependence other than normal emotional ties are shown to exist. And then they cite a succession of cases for that proposition. And they cite, we note, as I say, that that is the same formulation as we originally saw in the Commission decision in S. But here they've cited a succession of cases for that. Unity and the Netherlands, that's a decision of the Commission from 2000. Eminet is a decision from the court itself in 2007. Senchi Shak and Finland is a decision again of the court from 2014. We've checked, those cases aren't in the bundle, but each of them cites directly the S and the UK formulation that I took you to from the Commission. And you'll see then how that is applied at paragraph 47 on page 1583. And they conclude on the facts of that case, perhaps unsurprisingly, member of the family, as it were, the core family unit, this is father and son we're talking about, but also, in addition, relied on the fact that DB had suffered from Down syndrome, had communication difficulties, and that there therefore existed the additional factors of dependence that were required. One sees that towards the bottom of page 1583. Do you see that?
He was fully incapacitated.
Yeah, exactly. But what the court is doing, is the essential point, is applying the sort of dependence test that we saw described in the Khan case and in the S case, and indeed in those other three cases cited in paragraph 40. Its dependence isn't just clear and committed support, this is genuine dependence. They conclude on the facts that there was such, but for the reasons given.
And there was a finding by the domestic court that there existed additional factors of dependence.
Yeah, the lady has it. Then Kumari and the Netherlands is my next one. That is behind tab 61. And that is a decision of the 19th of November 2024. Page 1696. So 1696, Kumari and Netherlands, tab 61. And again, we've devoted a fair bit of time to this case in our skeletons, you'll recall, between paras 12 and 17, because this struck us as being an important case, not least because the European Court went out of its way to summarise where the case law had got to and to try and draw important distinctions as to how that dependency principle gets applied. And in short, what is happening here, I'll come to the detail in a second, but the S and the UK formulation requiring dependency as the test is reiterated, but in this case it's explained and analysed on a review, a very recent review as it turns out, because November 2024, of the relevant authorities. And that review indicates, we submit, and the European Court of Human Rights holds, that dependency means dependency, if that isn't too trite a submission. It means that one person is compelled to rely upon the other, such that reunification is necessary because of the degree of dependence. Not just that one person provides some support to the other. So in this case, we're dealing with the reunification of the applicant with her adult son, who was a long-term resident of the Netherlands and a Dutch citizen. The facts start at page 1697, and can I invite you just to cast an eye down, perhaps paragraphs 5, 6 and 7 to start with. I say to start with, what I'm going to do, if I may, is to summarise the facts as they develop, because they do develop a bit in terms of the claims made and the decisions made by the domestic courts. But if I give you those, I'm hoping that you can take that from me and dip back in as necessary when we get there. But the applicant, as you see, was an Indian woman, the mother. Her eldest son was the one who was legally resident in the Netherlands. And it was the eldest son who applied on her behalf for a provisional visa on the basis, see paragraph 6, that her presence, that is the mother's presence in the Netherlands, was, quote, necessary for his mental recovery and that of his spouse in connection with coping with the death of their prematurely born daughter. And that was supported, that need, by a psychologist's letter. So the original claim, as it were, is that the son is the one who is in difficulty and needs the support of the mother who is outside. What happened then was that, as paragraph 7 indicates, the relevant Dutch authorities rejected that application under Article 8 on the basis that, as you see from paragraph 7, the applicant's support showed willingness to help as is common in a good relationship between a parent and an adult child, and that a special dependency, as they put it, transcending normal ties, where family members can no longer function independently, had not been shown to exist. So that was the nature of the conclusion reached by the Deputy Minister of Security and Justice in 2016 as per paragraph 7. There were then, as you see from paragraphs 8 through 12, additional allegations of dependency and elements of dependency, this time the other way. In other words, the mother now being dependent, it was said, on the son. You see those summarised in paragraphs 8 to 12. In effect, what happened was that in the meantime, as it were, or during the decision-making process and the resolution of that in the courts in Holland, the applicant's spouse had died to create, it was said, such dependency, and the daughter in India lived very far away from the mother, it was said. The nature of the test, as I've summarised it, in other words, dependency transcending normal ties, no longer able to function independently, and so on, that test and its strictness as applied by the Deputy Minister, see paragraph 7, was directly in issue in that case. And that is evident from the fact, as you see from paragraph 19 on page 1700, that the regional court in Holland upheld the appellant's appeal domestically on the basis that the Deputy Minister had applied too strict a test. And the argument there appears to have been, well, is it exclusively dependent? Is it that strong degree of dependence, or is it something lesser, like support? That was the argument raised, see paragraph 19, which the regional court decided against the Dutch government. But the appeal court, as one sees from paragraph 23 following an appeal from that judgment by the Deputy Minister, overturned the regional court upheld the Deputy Minister's further appeal and concluded that there had not been shown to be additional factors of dependence other than the normal emotional ties of the requisite strength. So that's the backdrop to the case, a dispute between the domestic courts, or a disagreement between the domestic courts as to the rigour of the test, in essence, and that's the basis on which it goes to Strasbourg, because the applicant appeals then to Strasbourg, and then the court's judgment and its consideration of the principles, I hope, is all sidelined, mostly sidelined for you. 1703 is where it starts. Again, do you see the title, Court's Assessment, General Principles, above paragraph 34. And you see what is now a relatively familiar setup of the principles.
Well, except they start by saying it's essentially a question of fact depending on the existence of close personal ties.
That's exactly what we saw at paragraph 39 or whatever it was of Bierski. And then they go on to consider what that means. So 35 is normally limited to the core family, and then still in 35, no family life between parents and adult children or adult siblings unless they can demonstrate additional elements of dependence involving more than normal emotional ties. And then they specifically note, as part of their review of all the case law, they specifically note that that interpretation originates from S and the UK. Remember, that was the Commission case we looked at first. See paragraph 36. And it cites the same cases in support of that in the previous paragraph towards the end as the Bierski case did, Kwaki and T, Senchi Shak and Emanet, and then refers to S, which, as you'll recall, had only been referred to by derivation in the earlier Bierski case at paragraph 36. And then between 37 and 43, there's a passage of real significance, because the European Court, we submit, then sets out to clarify the combination of elements that is likely to be key in considering that accepted headline test of dependence involving more than the normal emotional ties. It does so specifically in order to clarify the position. And you see that from the final line of paragraph 37 on page 1704. Several case law examples are provided below by way of further clarification. So they're going out of their way to clarify what that means by reference to the case law. At 38 and 39, it then considers cases in which health conditions have existed. And one can obviously see that if you're in the territory of health conditions, as most of these cases are, you are, as it were, at least in the foothills of some form of argument about dependency, but it considers the cases in which health conditions have and have not led to the requisite dependency, including Bierski. So can I invite you to read 38 and 39, please?
And you see daily life in 39.
Yes, I'm grateful. I'm sorry, that's probably right. I got it wrong. Yes, also that concept's also in 41, I think. But 38 and 39, if you would, to start off with. So just pause, and you see the citation of A.W. Khan in 39. So just pause at the end of 38 and 39. You've got, we submit it perfectly clear from the way in which they've done this, the court, that dependency is the test. And it's also clear, we submit, that the hurdle is a high one. They're dealing with medical condition cases in both 38 and 39, so you've got that additional element beyond the facts that exist in this case, we note. But what is within the concept are cases where the medical condition requires, and I take the words from the first sentence of paragraph 38, constant care and support from other family members, and 39, not in, as it were, other cases where the medical conditions are serious, but not, to use the wording in 39, entirely incapacitating. Entirely incapacitating is the wording that strands 1704 and 1705, and you see that idea returned to in the latter few lines, or the last few lines of that paragraph. Paranoid schizophrenia, which while very serious, did not incapacitate the applicant to the extent that he was compelled to rely on his family's care and support in his daily life. So those paragraphs we submit clarify, if necessary, We're concerned with dependency, not sufficient support, and you need health problems of that degree of seriousness to bring yourself within the concept of family life as an elucidation of the idea of dependency involving more than the normal emotional ties. Financial dependency is then a subject specifically dealt with at paragraphs 40 and 41 of the court's judgment, and again that may be of some significance in this case. And the court's key conclusions, as you will see, are perhaps best summarised in that final sentence of paragraph 41. Financial dependency, and we would add, even if it is financial dependency, you don't get anywhere near it if it's not financially dependent, but even financial dependency has, quote, never been sufficient on its own to constitute additional ties of dependency and accordingly family life between adult family members. And we would submit that if financial dependency is insufficient, a fortiori financial support must be. We would also, and finally on this case, invite you to note, on the principles of it at least, paragraph 42, that is considering the presence of other family members, whether, other family members in that case and in ours, who are outside the jurisdiction, who are abroad, who can provide care or other viable alternatives. That is a relevant factor to determining dependency. Unsurprisingly, if you're going to assert that you're in the United Kingdom, for example, you're the only one who can do it, it's obviously relevant to consider whether there's someone who might be able to help in the foreign country. And that's the idea that is being dealt with in paragraph 42, along with the substantial links with that foreign country. And again, one can understand why. You are not, or you're less likely to be dependent upon the sponsor in the convention state if you have other options or other support networks in your country of origin. And so one sees then those principles applied to the facts of the Kumari case, and it's of some importance to note these in paragraphs 49 really through to the end of 46 through to the end of 52. And I just invite you, it's probably quickest to invite you to cast an eye down those paragraphs. So you'll note as you read, if you would, that 46 to 48 is all about the son. You remember there were two ways in which the dependence claim was put. One, the son saying, I'm suffering from these difficulties as a result of the premature death of the daughter, I think it was. So 46 to 48 are all about that, and then 49 moves on to the mother's later asserted dependence upon the son. So that we've got both angles of dependence being dealt with. Basically see in that application a reflection of precisely the principles that we saw delineated in 38 and following of the court's treatment of the principles. So you note, for example, in relation to the son's dependence or alleged dependence on the mother, para 48, look at the language which is used. The court accepts that the death of the daughter has caused great impact on his mental well-being. There's no evidence before it which would suggest his condition was so severe as to entirely incapacitate him, and then noting that he was able to function in his everyday daily life together with his spouse and sons in the Netherlands. And then when they turn to the mother's dependence on the son, 50, paragraph 15, no indications that the applicant was unable to get by with the medical care in India and other forms of care and support and assistance as provided by her housekeeper, neighbour and friends. Not demonstrated she suffered from a physical or mental disability or illness of sufficient seriousness, or that she was in need of constant care and support from R in order to cope with her everyday life. And then they pick up and reiterate points about financial dependency. They held that she wasn't financially dependent because it could be continued from afar. That's the first sentence. But in any event, they say if there was financial dependency, that wouldn't do.
Says it was a majority decision.
My lord, it does. We don't know by how many because it's an inadmissibility decision, manifestly ill-founded.
So the respondents minimise the effect of this decision, say it's just a single chamber, not grand chamber, has no, I think they say it's an outlier. What do you say about that?
My lord, I say it is evidently not an outlier for the reasons that I've given. It builds on a line of authority that has been in place since S and the United Kingdom way back in 1984. It has been consistently repeated and approved, the idea that the test is genuine dependency. All of the cases that they rely on in 38 and 39 to illustrate the distinctions they draw are cases of the European Court, indicating the height of the hurdle. All they've done in this case is to collate them and to identify and draw a principled approach from the application of that headline idea to the facts of particular cases in a helpful way. So it is preceded by a long run of clear and constant authority, and it is followed, as I will demonstrate in a moment, even in the short time since it was promulgated, by authority which applies it. My lord, I hope you will receive Mr. Hussein's normal letter. Would you mind rising for a moment or two to enable him to take a comfort break?
2 minutes. If that's
subject.
Right.
Court riseth able.
Thank you very much, my lord. Apologies.
I'm going to go next, if I may, to Alvarado in the Netherlands, which is tab 62, page 1709. This is the decision of the
Alvarado.
Sorry, the page number again?
1709.
Thank you.
You see that this is a decision of the court. I think in March 2025 or December 2024, now it's not. And I wanted to go, if I may, to the, speed it up a bit, to the principled approach. And I wanted to do so simply to demonstrate that if you look at paragraphs 35 to 45, under the heading General Principles, starting on page 1722, you have an exact repetition of what we've just seen from Kumari.
Same division of the court.
It's the same division of the court, it is.
Is this majority too?
My lord, it's a bit difficult to know that, I think, because this one,
It says it at the end.
yeah, there'd been a violation of Article 8, I think, but on rather different grounds, so weren't rejecting it as inadmissible.
No, it doesn't say it's majorities.
No.
It's unanimous.
Yeah, unanimous, yeah. But they find a violation there. In that case, the applicant was incapable on the facts of caring for himself.
And the whole family was in the Netherlands.
Yeah, exactly. As one sees from, for example, paragraphs 5 and 6 for the facts and paragraph 50, perhaps 49 and 50 if you read those. And you see in particular the conclusion and the way it's expressed in the final sentence of paragraph 50 on page 1726. And they then find a violation on the basis that the domestic courts haven't carried out a sufficient analysis of the merits, as you see from paragraph 55. That doesn't need to trouble us. What's important is that they apply directly the principles that they clarified in Kumari, and then they apply them on the facts in this case by application of the incapacity, such a degree of incapacity that he was compelled to rely on his sister's care and support in his daily life. That was sufficient to enable a finding of family life to be made.
And paragraph 50.
Paragraph 50, yeah. Final sentence in particular.
Yep.
And then Demirci in Hungary, that's behind tab 63, and it starts at 1728 in our May of this year. a different section of the court, second section this time. And the facts you see summarised shortly at paras 2 to 7 on page 1730, over to 31. See the nature of the Article 8 claim that was made from paras 63 to 65, if you go on in the judgment. Page 1740. Perhaps 64 and 65 would do it.
So 60.
64 and 65 in the party
The submission.
submissions. Yeah, just take that as a convenient summary of the facts.
Mm-hmm.
And so far as the principles are concerned, can I invite you to turn your attention to paragraph 70. They conclude in 69 that it's appropriate to analyse this as an Article 8 family life case. This is parents and children, adult children and parents. But look at 70. In that connection, the court notes that the general principles concerning the existence of family life in the immigration context have recently been summarised in Kumari. They then turn to whether cohabitation is a requirement for a relationship amounting to family life. And they reiterate the dependence test with reliance on the now well-known bundle of authorities at 72. And then they apply.
Were these cases put to the Upper Tribunal?
Kumari certainly was. And Averada was as well.
This line of cases?
Yes.
Mm-hmm.
And then 74 they apply it. I invite you to have a cast an eye down 74. And I do so because you'll see that they pick up the language of A.W. Khan. Do you remember we looked at A.W. Khan as the very first one? You look at para 74 on page 1742. And you'll see a few lines down that they refer to A.W. Khan, but it's a bit that precedes that they're taken from Khan, which is of interest perhaps. Third applicant suffered from problems with her eyesight. Hadn't been demonstrated that her condition was sufficiently serious for her to require constant care and assistance from the first applicant in order to cope with her everyday life. Do you see that? Compare A.W. Khan, Konstantinov and so on. As for the alleged financial dependence of the third applicant, the court has found that financial support could be provided from a distance. We've seen that in a number of cases, haven't we? And in any event, such dependency on his own has never been considered sufficient to constitute additional ties of dependency. See Kumari. So they hadn't been shown to exist, not family life. Applying Kumari. 73, of course. 73, my learned friend, would like you to read. Can I invite you to do that? Lords, my lady, in brief, I've made the points already, but just to summarise them very, very briefly, 5 short points by way of conclusion on the Strasbourg case law. 1, clear and consistent line, since S and the United Kingdom, that you need to establish dependency. 2, nothing whatever in the Strasbourg case law to suggest that the test is simply genuine or committed support, and indeed very real concern in terms of the breadth of that, if that was the test, a concern evidently shared by the European Court, hence they felt the need to clarify things in Kumari, and that was then taken forward, as you know. Thirdly, also clear and consistent line in the Strasbourg Authority as to what that headline mantra, dependency going beyond the normal emotional ties, that one, what that actually means. And we've seen, particularly from Kumari, a deliberate case, or a case deliberately clarifying the correct principled approach to that concept. We've seen that in Kumari. We know what it means. And we know the rigour of it. I say clear and consistent, without wishing to repeat the answer I gave to the Master of the Rolls on that issue, because we've had the lead up, and all the cases, including, for example, A.W. Khan and all the rest of them, to Kumari. Kumari then pulls the case law together and says this is what it means, and that is then applied in the first case by the same section. So one, I suppose you could say, well, it's the same section, so who cares? But in identical wording, and then another section effectively accepting and applying the Kumari approach. So clear and consistent as to what it means is the third point. And the fourth point follows on from that, which is that all of those principles and that approach and the clarification in Kumari evidently now represents the principled approach in the European Court of Human Rights, which the court in this jurisdiction, in the domestic jurisdiction, must take into account under Section 2 of the Human Rights Act, without even the need to add the can you be fully confident it's the other way, which you plainly can't under AB. That's the fourth point. Fifth point is that none of this, of course, detracts from the fact-sensitive nature of the question. We've seen that paragraph invariably introduced as it were, the lead-in. It's all fact-sensitive. But we're dealing here with that fact sensitivity in effect applying to a legal standard and a principled approach to which the facts must then be directed. And it's that the Strasbourg case law has provided clarification and assistance on.
Can I just ask, now that you've given us your 5 principles, I mean, Article 8 also refers to private and family life. All the analysis appears to be family life. Does private life have a different test? Does it take it any further?
My Lord, I don't think on the relevant case law that we're concerned with it does. I don't think anyone suggested if you couldn't bring yourself within the family life definition, you could, as it were, achieve a different result by relying on private life. But what these cases have tended to do, and you remember that paragraph in at least one of the cases saying, how should we analyse this? And the court concludes, oh, well, I think we should analyse this as a family life case. And that is, I respectfully submit, the approach that Strasbourg would take. They'd look at this as a family reunification case. They would apply that to all the principles that apply in the family reunification context. I don't think there's any suggestion that you could then fail under that, but win under private life, if that makes sense.
Thank you.
Can I turn to the domestic position? And just to start with where I'm going to end up, as it were, so you know where I'm going. Our core points on the domestic position are these. It's been the intention of the domestic courts throughout to endorse and apply the correct test that Strasbourg applies for when family life is established in this sort of context, applying the Article 8 case law. I emphasise that as obvious perhaps, but there isn't a case, which I suppose might technically be permitted, although it might be jolly difficult for following AB, but there isn't a case in which the courts domestically have said, well, there's the Strasbourg case law, we don't like the look of that, we're going to consciously depart from that. So they're always trying to apply what they conceive to be the correct Strasbourg test. Secondly, there are a number of domestic cases, including we submit or will submit the decision of the House of Lords in Beku Betts, which endorse the test as one of dependency. Didn't have the benefit of the clarification in Kumari, but they're doing a dependency test. What appears to have happened is that the judgment of Lord Justice Sedley in Kugathas has led in some subsequent cases to an uncertainty over whether the threshold is dependency or support, and has led in a couple of cases at least to the courts domestically saying that all that is required is support, including our two tribunals here. But there is, I respectfully submit for all the reasons I've just gone through, a very clear and constant line of authority in Strasbourg that's always existed but is now all the clearer for Kumari, and the domestic case law subject only to the rules of precedent we submit needs to be brought into line with that, and indeed should be brought into line with that on the basis that the courts are always, and have always been trying, to apply the Article 8 case law. In any event, and if necessary, which it is not, we have the AB point. You couldn't, in principle, as a domestic court now, strike out on your own away from this conception of dependency for the very simple reason that you couldn't possibly conclude that you could be fully confident that the Strasbourg case law would do anything other than apply Kumari. I turn then to Kugathas.
We're going to look at AB at some stage, are we, just for completeness?
My Lord, we certainly can. We could probably do that now if that was a convenient point in your notes.
I would find that helpful, actually, yes.
29, tab 29, page 586. You'll see that they begin, this is a Supreme Court case in a very different context. This was about juvenile offenders being placed in solitary, effectively. And the key passage for your purposes, I submit, runs between 54 and 59, starting on page 610. And I'm not going to go through all of it, because you'll see that what is being done by the Supreme Court as part of, in this era, if I'm allowed to call it that, a general re-evaluation of the way in which the Human Rights Act principles worked, they're tackling Ullah. And you'll see the reference to Ullah in paragraph 54. And the key paragraph we submit is the one that I hope you have sidelined, which is 57, starting at the bottom of page 610. And the thing I'd invite you to note as you're reading that, or to double underline mentally as it were, is the double reference to the idea of being fully confident. You see that? So the paragraphs that precede that are, as it were, analysing the rationale for the Ullah principle and so on. But that is what the Supreme Court has now repeatedly taken from this case, this idea of fully confident. 53, and I don't know if a friend would like you to have a look at it as well.
Yeah.
I can dwell more if you'd like me to dwell more, but it's 57 that encapsulates the principal approach.
Did we not recently do a case in this court dealing with these principles? Anyway, doesn't matter.
My memory has gone fading on me. I'll try and remember. If it pops into my head, I'll remind my lord. I'm sure we have done.
Yeah, no, I'm sure I have. It just always helps me to get the principles in focus if I remember the last thing I said about it.
Okay, well, I'm hoping the last thing you said about it was see paragraph 57 of the Supreme Court judgment.
May well have been.
It may well have been a feather. I'll try and remember if I may. Can I let that bubble in the back of my brain as we go? Kugathas I wanted to go to.
Kuthakos, yes.
Tab 2, page 21. This is the Lord Justice Sedley case. And you have the head note for your assistance.
Sorry, which tab?
Sorry, my lord. Tab 2.
Oh, tab 2.
Tab 2, page 21.
Yeah. 2003 seems a long way away.
Yeah. Jan 23. And paragraph 3 for the facts.
Yeah.
You will see that he was a Sri Lankan who sought asylum in the UK. Asylum was refused. Father had been killed in Sri Lanka by the Sri Lankan security forces. Issue as to whether his removal from the UK would breach his A8 rights on the ground of family life. The family in question, as you know, was not in the UK but was in Germany there. Mother, brother, sister, sister's husband and her infant child were there. His sister visited him regularly in the UK, or visited him once in the UK, sorry. There had been regular contact with them all by telephone. Paragraph 14, 1-4, some significance. Mr. Tam had cited S and the UK, which we've looked at. You see that on page 26, paragraph 14. And Lord Justice Sedley accepts as the proper approach. You see that. Those are the last two lines of paragraph 14. He's accepting as the proper approach. Paragraph 14 on page 26. That citation from S. So in other words, accepting as the proper approach the dependency formulation from the Commission in S and the UK. And we submit that he was right to do so. It's the bit after that that becomes problematic. Doubtful, we submit, whether he was he correctly conceived what that meant even at that time. He seems to have taken that idea in paragraph 16 as leading to a real and normal or committed relationship test to be applied to family life with other adult family members, even there of the core family. But the cases he cites for those ideas, real and normal committed relationship, provide no support for that at all. Abdul Aziz, which may come back to Underground 2 perhaps, is a case about a married couple, not family life beyond couples and their minor children. Marx was about a parent and an infant daughter, and Beljudy, the existence of family life wasn't disputed. None of them involved any departure from the S and the UK formulation. We also submit that it tried to introduce those ideas of committed relationship and real and normal as if, as it were, they were a synonym for, or to be equiparated with, dependency cannot be right. They may have been phrases used in those cases to describe the concepts that they were dealing with there, but S in the UK, which he correctly accepted as the proper approach, imports dependence.
Well, you say 17 is wrong.
I do. And I say, even if it wasn't wrong at the time, it has now been shown to be wrong, because you now have a clear and consistent bunch of case law on the very issue of adult relationships outside the core family, as I've gone through. So we submit that 17 is wrong, was a misstep. And the Court of Appeal can and should say so. And we note, in defence of Lord Justice Sedley, if that's a correct way of approaching it, that his intention appears to have been to try and apply the Strasbourg case law. We respectfully submit that that was obviously the right approach, and he was right to accept S. The misstep was in what S meant, taking, as it were, the idea of dependency down a notch, or quite a few notches. And we note that when he came to apply it, at paragraph 19, he concluded that even on that test, the test as he conceived it to be, the facts didn't meet it. Regular telephone contact between the applicant and his family in Germany and the visits concerned were not enough, even on his conception. And I make that point simply to note, by way of echo into the facts of this case. See paragraph 19, 1.9. Most of us have close relations, and so on, in paragraph 19. Lady Justice Arden, at paragraph 25, we submit, correctly conceives the position, page 28, paragraph 25, saying, in my judgment, a family life is not established between an adult child and his surviving parent or other siblings, and that something more exists than normal emotional ties. She then cites S from the UK and Abdulaziz. Such ties, she says, might exist if the appellant were dependent on his family, or vice versa. That, we respectfully submit, is correct, was correct at the time, and is now demonstrably correct, given the line of Strasbourg case law that I've taken you to, including in particular Kumari. And we note that Lady Justice Arden, coming back to my lady's question earlier, does not agree with or endorse the support read down, if I can put it that way, in Lord Justice Sedley's judgment at paragraph 17. The third judgment is that of Lord Justice Simon Brown, and he says nothing about that relevant test. He doesn't endorse either Lord Justice Sedley or Lady Justice Arden's versions of the test. So that's the precedential position, as it were. It's a judgment of one, in effect, not adopted by Lady Justice Arden, with Lord Justice Simon Brown not opining on the point. So that's, as it were, the start of the misstep. The post-Regathas domestic cases, can I pick those up? I'm going to come specifically to Mobeen, the Court of Appeal, the Lady Justice Carr case at the end of this, and I'm going to take the intervening cases rather more quickly, if I may. And I do so despite the fact that the respondents in their skeleton at paragraph 30 assert that the Lord Justice Sedley test, if I can call it that, in Kugathas, has been endorsed and applied domestically in numerous subsequent cases, and a list of cases is cited in that paragraph.
Sorry, who says that?
The respondents,
yes,
my lord, in their skeleton at paragraph 30. They list a whole bunch of cases and say this is applied Sedley, Lord Justice Sedley in Kugathas. My short submission, I don't want to take up long on it because the position is as it is in Strasbourg, and you've had my submissions on Kugathas itself. The position in any event is far less clear. Some of those later cases which are cited in support of that bold proposition, inaccurately we submit, some of them actually endorse the dependency test per Lady Justice Arden, not the Lord Justice Sedley support test. Some of them, it might be thought, are a bit confused and seek to endorse both tests, even though they are inconsistent with each other. And some of them support the support test. I'm not going to show you all of them, but to take by way of example, ZB Pakistan, which was the first of the cases that the respondents cite as endorsing Lord Justice Sedley's approach, ZB in Pakistan and the Secretary of State for the Home Department, authorities tab 9, at page 158. And we submit shortly in relation to this that it is actually a case that endorses Lady Justice Arden and dependency. You'll see the facts from paragraph 7. I'm now on page 159. Take that relatively briefly. The law is picked up at paragraphs 22 and following, page 163. Note in 33 they've cited the Commission in Essen, the United Kingdom. Do you see that? Top of page 167. 34. You see the citation. The citation is from Lady Justice Arden, not Lord Justice Sedley.
He described the decision as now elderly, but he held that its principles were still correct.
And my lord, we would agree with him if you cite Lady Justice Arden, which he then does. And then you will see in 36 another decision is cited in which dependency is the test. Beku Betts. Again, we submit Beku Betts endorses the dependency test. That's tab 6, page 93. And the main issue in Beku Betts was, of course, the proper interpretation of what is now Section 82 of the Nationality, Immigration and Asylum Act 2002. I'll come back to that. But for present purposes, paragraph 7 in the speech of Lord Brown, for the core facts, claimant comes to the UK, age 19, is now 29. Para 10, sought asylum and indefinite leave to remain, that was refused, challenged under Article 8 by reference to other family in the UK. On the question of whether there was Article 8 family life, can I invite you to go to paragraph 39. And you'll see that in paragraph 39 what is said is about dependency. But the dependency between the appellant and his mother here clearly engages Article 8. And Lord Brown then cites Mokrani in France. And Mokrani in France was a decision from 2003 reciting the S and the UK formulation. And you'll see again, end of paragraph 39 on the adjudicator's findings of fact, such additional elements of dependence can properly be said to exist in the present case.
Let's read page 12.
Paragraph 12, my learned friend draws attention to. Can I invite you to read that?
12.
12, my lord, I think. Well, there are then a series of cases which might be thought to be sitting on the fence or confused about what the test is as between dependency and support. And they, by and large, cite both dependency formulation and the support formulation. And into that category falls, and I'm not going to have time to go through them all, but into that category falls PT Sri Lanka, tab 18, page 406. And the relevant paragraphs in that, just for your note, I'm not going to invite you to take it up now, but just for your note, paragraphs 23 to 26, in effect it held that there was no presumption one way or the other, said that Kugathas has to be understood in the light of the subsequent Strasbourg case law, and the case law cited at paragraph 23, and indeed paragraph 47 within the quotation there, included two Strasbourg cases citing the dependency formulation. Rye and the entry clearance officer, tab 19, page 420, the relevant paragraphs are 17 to 20, citing both Lord Justice Sedley and Lady Justice Arden in Kugathas, and at paragraph 36 considering the position by reference to both support and dependence.
Where's Rye?
Rye is 19420, and the relevant paragraphs are 17 to 20, citing both of them. These are cases which sit on the fence and or apply both. And then 36.
Sorry, James, which paragraph?
17 to 20 and 36. Udin, tab 24, page 499, relevant paragraphs in that case, 26 to 31, again citing both Lord Justice Sedley and Lady Justice Arden, seeming at 31 to accept that dependency is required, but saying that the irreducible minimum, as it's put, is real and or effective or committed support. And then we get to Mobeen, which we've addressed in our skeleton at paragraphs 18 to 19. And that is in the authorities at 25. Sorry,
25.
26.
25. 26.
Tab 26,
You're absolutely right.
page 523. See paragraph 1 for the facts. Appellant, as you see, was a 66-year-old widow, was born, lived, married in Pakistan. She had a son and two daughters there, since became residents of the UK and British citizens. She came to the UK on a visitor's visa, then applied within the UK for leave to remain. That was refused. The issue in the appeal was whether there was a breach of Article 8 in relation to the refusal of her having sought leave outside the immigration rules. There was a survey of the Article 8 case law. This is, I should say, June 2021. Survey of the Article 8 case law at powers 44 to 50. The court refers to Kugathas and subsequent Court of Appeal cases. There's no reference to Strasbourg case law and no reference to Beku Betts. And then in 46, you'll see how the matter is put. We emphasised a third sentence. Normal emotional ties will not usually be enough. Further elements of emotional or financial dependency are necessary. albeit there's no requirement to prove exceptional dependency. Not quite what that means, but exceptional dependency. So is they're recognising the necessity of elements of dependency. Correct then a fortiori now. Later in 46, she treats the existence of effective, real or committed support as an indicator of family life.
So she relies on AU and Sing 1 for the proposition that the ultimate question is whether this is a case of effective, real or committed support.
Yeah, she does.
What do you say about those cases?
My lord, we say that that is plainly not the test on the Strasbourg case law.
So you say this case is wrong?
I do. Or it's been at the very least overtaken by the Strasbourg case law.
But
Close personal ties, plainly.
what happened in this case? I mean, it's not really fair to say it's overtaken by the Strasbourg case law. It's simply doesn't take account of S versus UK and other cases.
It doesn't seem to, and doesn't take account of Beck Betts, which relied upon them.
So it's inconsistent with Beku Betts in the Supreme Court.
Yes. But again, I don't want to get too worried about making that submission, because as you know from RJM paragraph 66, if the Strasbourg case law is at the very least moved into a place where it's inconsistent with the Court of Appeal authority, the Court of Appeal is entitled to move with it.
We see that in what case?
RJM.
RJM. But I mean, what if, I mean, I don't know whether this, in this case, we haven't got a full report, so we don't know what was cited to the now Lady Chief Justice, do we? But she refers to Rasgar. But I mean, the Strasbourg authority, I mean, Kumari is not, according to your submission, not doing anything different from what had been done before.
No.
So, I mean, let's say the position was that all the previous Strasbourg authorities were cited to the Court of Appeal. The Court of Appeal decides inconsistently, deciding under Section 2 to have regard to but not to follow the Strasbourg jurisprudence. If that were the case, I'm not suggesting it is, I'm just postulating, what do we do?
My lord, you go with the Strasbourg case law. You're there under Section 2.
Where's RJM then?
RJM is tab 8, and the relevant paragraph is 66, page 156.
66.
66 on 156. Perhaps started at 65, but 66 is the key.
So it's about per incuriam.
It's about per incuriam in part, but then they go on, as you see in particular, the the real principle of interest perhaps is in the final sentence of para 66.
Yes.
Justin's read 67 as well.
And 67, my learned friend wants you to read.
Court of Appeal may be less ready to depart from one of its earlier decisions inconsistent with the decision of the European Court of Human Rights than one which is inconsistent. So we do, don't we, need to look at what the ratio of Mobeen is.
More being, it might be thought it didn't much matter on the facts because of the way they disposed of it. See paragraph 8 of Mobeen, if you go back to tab 26, page 537.
Slightly curious because they allowed, the Court of Appeal allowed the appeal on the existence of family life, but dismissed it on proportionality.
So which page?
Page 537, para 58. And they appear to there be applying a real dependency test. The difficulty, of course, is what it means, and the principal difficulty is of the description of the ultimate question, as they put it in para 47, which we submit starts from a misapprehension of the Strasbourg case law and proceeds to a misapprehension of the significance of Kugathas and ignores Beku Betts. Well, the RJM principle is only a free-to principle, but I do respectfully submit in relation to that although it's only a free-to principle, all of the courts in all of these cases are essentially trying to do the same thing. This is not a domestic legal approach. This is an approach which seeks to give effect to the case law of the European Court of Human Rights as the body which has carriage of the interpretation and the principles to be applied under the Convention. That's what they're all seeking to do. No doubt that underpins the free-to principle in RJM, at least at this level. And it's now absolutely clear that the principle in Strasbourg is not, and perhaps never has been, a principle of clear and committed support. There's simply no reference to that. There's no application of that. Indeed, the case law in Strasbourg is directly contrary to that. It's all about, and has always been all about, dependence.
So clear and committed support, those words come from Kugathas.
Yes, that's the source of them in domestic jurisprudence.
And where did Lord Justice Sedley get those words from?
I think Abdulaziz and the other cases that he cited, which, as I indicated, were about different things.
So in other words, they're stray dicta in cases in which the existence of family life wasn't in dispute.
Either wasn't in dispute or was about the core family,
Yeah.
where that might be an apt description. And the cases cited in para 47 in support of the ultimate
Para 47 of what?
of Mobeen, page 534.
Yes.
I've taken those words, effective, real or committed support.
So where's
Real.
AU in this bundle?
Oh, same as Udine, is it?
Is it the same as Udine?
Well, I think it is. 24499. My note. I gave you the references into that earlier on. But my respectful submission is that these are all cases which essentially build on the Kugathas error, and, if necessary, which have been overtaken by the Strasbourg case law.
Yeah. I mean, I understand the submission, but I do think there has to be a little bit of rigour in putting together what has actually occurred.
Yeah.
Because I, for my part anyway, don't find it an easy submission that we should simply sweep away what appears to be a binding decision of this court if it has a misapprehension as to Strasbourg authority. I mean, for example, we don't know what was cited in terms of Strasbourg authority. We know now that Udit was cited. What about Sing 1? Is that cited? Is that in the bundle?
This is Pawandeep Singh. It's a Mundi, Justice Dyson and Mundi, tab 3.
Tab 3.
Tab 3. And did you give us references very quickly then to...
My lord, I haven't, but I can easily get those collected and make sure you have them.
I mean, I find it, for my part, I find it very difficult to understand how such a error could be made. There's something very different about clear and committed support from dependency.
Yeah. But that concept derives from Lord Justice Sedley's judgment in Kugathas.
But except his judgment in Kugathas actually says that he's bound by S and the UK, which talks about dependency.
Yes, but then
So is it being said, I mean, I'm asking, not telling, I
Yes,
don't
yes.
know. Is it being said that clear and committed support is just the other side of the coin from dependency? Obviously, support looks at it from the point of view of the supporter, and dependency looks at it from the point of view of the supported. So they could be two sides of the same coin.
my lord, I don't think that flies, I'm afraid, and it hasn't been taken.
It flies insofar as what I said is correct.
Well, my lord, it may fly as a matter of perfect logic, but on the case law, it's evident that maybe the same thing. But on the case law, it's evident that they are different things. And you only have to look at the First Tier Tribunal judgment in this case, which I will come to in a moment, which says you don't need dependency. You need clear and committed support, and that's different. They find as a fact that there wasn't dependency. But what appears to have happened is that...
Well, if somebody provides clear and committed support to another person, that other person must, in some sense, be dependent on the person from whom they receive clear and committed support. The question only is the level of dependency or the level of clear and committed support. So are we arguing about how many angels can stand on the point of a needle, and are we really looking at the same concept and talking about the difference between absolute dependency and partial dependency, or not?
My lord, we are talking about differences of degree, of course. We are talking about the sufficiency of dependence. That's the phrase used in Kumari, and indeed in the subsequent Strasbourg case law. But what's happened is that the mantra from this in the UK has been taken as being dependency going beyond normal emotional ties or whatever. And then the question has been, what does that mean? And my submission on the Strasbourg case law is it's now absolutely clear what that means. Dependency means dependency in a real sense. And indeed, on the Strasbourg case law, it's evident that that means that you can't get on with your daily life without it. It's genuine dependency. And that, I submit, is a whole different concept to simply saying you've shown clear and committed support to the individual. Of course, on one view of the world, clear and committed support is a necessary ingredient of dependence. But it isn't the same thing. And it hasn't been taken to be the same thing, including in this case.
Well,
so it isn't angels dancing on the head of a pin. These are genuinely different concepts, which the Strasbourg court has illustrated by the way in which it has approached the facts of the cases and described the principle.
I understand that point. I understand the Kumari example, but I think this seems to have been caused, if I can sort of make a diagnosis rather than a decision, seems to have been caused by the loose use of language. Now, you may not be surprised to hear this coming from me, a Chancery lawyer, but it's very dangerous to use language loosely so that you then submit these are quite different tests, when the language actually might lead one to believe that it's only in the applications that they are quite different tests, so that you need to identify precisely what the European Court of Human Rights is saying, because even they talk about support, they may not talk about clear and committed support, because it is the other side of the coin from dependency.
Yes, but I've taken you through the cases in which they refer to support and have concluded in cases which could properly be described as clear and committed support that that isn't enough.
You see, the problem is Mr. Hussain is going to take us through these cases, and he's going to show us other passages that look at it from the other end of the... There are two sides to the telescope. You look at it either from the point of view of the supporter or the supported. And if you look at it from the point of view of the supporter, then you might talk about the qualities of the support. And if you look at it from the point of view of the supported, I mean, this is not a trivial point. If you look at it from the point of view of the supported, namely the person who is said to be dependent, then you will use different language, because then it obviously is a different side of the coin. Now, what I'm concerned about is Article 8 is about the right to family life. You said you were going to make submissions about whose family life is concerned, and your skeleton tells us that the only person whose family life is concerned is the sponsor in England. Now, if that's right, then it may be that the correct end of the telescope is from the point of view, in this case, of the supporter, because he is said partly to be the supporter, I suppose in some senses, because of his disabilities, maybe the supporter Ed. But, you know, I'm struggling for real coherence. That's what we need.
My Lord, yes, but that, I mean, I don't wish to trivialise this. Of course, my Lord, is to an extent right that you can look at it from the different perspectives of the supporter and the supported. But the line of principle that comes very clearly from the Strasbourg case law, I respectfully submit, is it doesn't matter which end of the telescope you approach the question from. What you need is a sufficient degree of independence to engage family life when you're dealing with adults.
A sufficient degree of dependence?
Yes. A sufficient degree of dependence. And the question then is, well, what is sufficient and what is not sufficient? Now, of course, ultimately that's a question of fact. But the case law indicates where that line is in principle to be drawn. And what the case law indicates is that in order to be a sufficient degree of independence, you have to fall within the principle that you can't get on with your daily life without the support of that individual. It's that repeated reference to incapacity. And you could describe the cases that fall on the wrong side of that line, if you remember the contrast between 38 and 39 in Kumari. You could describe the cases that fall on the wrong side of the line, i.e. not sufficient dependence, perfectly properly, as engaging clear and committed support from the relevant individuals, if you look at it from the perspective of the supporter. Not enough. So my submission in answer, I think, to the Lord, to the point my Lord is putting to me, is, of course you can look at this from different perspectives and from different ends of the telescope, but what the Strasbourg case law has clarified is not dependent upon which end of the telescope you choose to put your eye to. It's dependent upon the level of dependence.
Whose family life?
Well, it's dependent in part on whose family life, but it's not. That doesn't determine the matter. Even if the position was that you look at everyone you're still looking at adult children
But
abroad.
do you look at everyone? I mean, that's my question. Do you look at everyone? Article 8 provides that people have a right to private and family life.
Yeah.
And that should not be interfered with.
Yeah.
So who has that right? Obviously, the sponsor in this case.
My lord, we say yes, but this argument...
They say no.
They say no. This argument about sufficiency of dependence doesn't depend and isn't resolved by answering that second ground 2 question.
Well, it would at least tell you, if you were right, it would tell you that you look to see whether the sponsor is dependent upon his family abroad.
My lord, yes, but that would be quite a difficult submission in the light of the case law, where sometimes the people abroad are said to be dependent. You remember the way in which the argument in Kumari developed. There was a reliance upon both. The son said he was dependent, and the mother said she was dependent, and she was in India. But my submission is one doesn't need to overcomplicate it, because it's about sufficiency of dependence. It's about what that means. And we know, when you look at the Strasbourg case law, that even in a case where a medical condition is in play, and even where a case where there is, on any view, clear and committed support by one part of that asserted family, that won't do. And it won't do unless the person who is dependent is genuinely dependent in the strict sense, i.e. they are incapacitated to a degree where they can't get on with their normal daily life without that support. So this is a principle about how you define and how you approach, on a principle basis, that concept of sufficient dependence. You exclude normal emotional ties, because that's the headline contrast. You exclude financial reliance, even if it's dependence.
Well, we probably need to look at what the FTT did.
My lord, we do. Can I come to try and apply those principles to the facts?
Can we just, before we leave Mobeen, can I just ask you one question about paragraph 44?
Yes.
Because I just wonder whether you need to go as far as you do. What the Lady Justice Carr said was the existence of effective real or committed support is an indicator of family life. It doesn't say she approves or disapproves. And obviously, if you're talking about dependency, that may well be right.
Sorry, in paragraph 44.
Yeah, 46, sorry.
46,
Yeah. I mean, is that sentence in fact wrong, even on your test?
My lord, no, and I hope I made that clear when I was going through it. I drew attention to that as an indicator, that's fine. The worry is if you move to paragraph 47.
Yeah.
That's the worry. Much of what's said in 46 is fine. But it's that equiparation of the Strasbourg test of dependence with the questions that are identified in 47 that is problematic.
Thank you. Sorry to interrupt.
No, not at all, that's helpful. My lord, so far as we are concerned here, can I invite you to just take up the FTT decision, which is in tab 9, starting at page 139. And our first submission, for obvious reasons, is that the FTT gets the test wrong. See paragraph 18, 1.8 on page 142. I'm not sure what that's saying, but looks like it's saying that real, committed or effective support is a lower threshold than dependency.
That rather supports your submission, that they are two sides of the same coin.
That, well, maybe it is that, but he's certainly thinking that there's a lower threshold.
Yes, exactly.
Yeah, exactly. And you see that very clearly from 25.
But they may be wrong, right? I mean, that's what they're saying.
Yeah.
You say it's wrong because you say there is no lower threshold than dependency.
Yes, and dependency as defined and clarified.
Dependency as shown in the
Kumari.
Strasbourg authorities,
Yes.
including Kumari.
Yeah.
But, I mean, yeah. That's what you say is wrong.
We say that's wrong, and then you go to 25. It's critical. It's critical that it's lower. Correct to acknowledge that this is short. He's applying a genuine, effective and committed support test. Correct to acknowledge this is short of the appellants being dependent on the sponsor. But dependency is not necessary to establish family life. It is. So my lord may be right in perfect logic, as I accept it, but there may be flip sides of the same thing, and you're arguing about semantics, but in truth you're not. This is about the height of the hurdle that has to be overcome by the adult person asserting family life.
But you can only work out the height of the hurdle if you work out whether you're looking at the hurdle from one side or the other. And the points I've made to you are nothing to do with the height of the hurdle. They're to do with what is the nature of the test.
Yes.
And from whose side are you looking at it? Because the words are words of they're completely different perspective. So
my lord,
support
yes.
and dependence
Sorry.
are from two sides of the telescope. And I find this inaccurate, this sort of looseness, probably part of the problem. I mean, you may be absolutely and completely right, but for my part, I need to know what the test is before I can say whether you're right or not.
My lord, my submission is that the test is dependent. And the moment you introduce all these ideas about clear and committed support...
But dependent is actually a value judgment. Dependent is a subjective word. You can be dependent, I can be dependent on my grandmother, whom I visit on a Sunday afternoon at 2 o'clock for half an hour every week, because I find it emotionally very useful to go and see my grandmother at 2 o'clock on every Sunday afternoon. That's a perfectly reasonable use of the word dependent, but it is not what we're talking about here, plainly. I can agree with you about that.
My lord, yes, I hadn't quite finished my definition of what I was submitting was the correct test. Dependence is the headline thing, and more than normal emotional support. That's the contrast. Then the question is, what does that mean? And we know from the Strasbourg case law that it is a sufficient degree of dependence so that the dependent person, in effect, cannot go about their daily life without that support. That's the clarity that you get. That's why Strasbourg went through the cases it did in Kumari. It isn't just Kumari as an outlier. Kumari is analysing what the Strasbourg court has done before. That's why the distinction in 38 versus 39 is so important in Kumari. So that's the headline test.
Well, you're using the word support in your definition of dependency.
Oh, well, I only do that to try and buy it in. But it's a sufficient degree.
I'm sorry to be difficult.
No, of course, it's important to try and get it right.
This is a very important case.
It is.
You're asking us to depart from previous decisions of this court, and we must have clarity as to precisely what your submissions are, so that we know whether we can accept them.
Well, my lord, that is my submission. My submission is as I've described.
Dependency means that you cannot go about your daily life without that support.
Yeah.
Support from that.
Which is designed to encapsulate that
Support
distinction.
from the person upon whom you are dependent.
Exactly. And the worry is that if you do treat genuine and effective and committed support as being simply the flip side of that, or the other side of the telescope, there is at least a risk. I'm sure it wouldn't be a risk that my lord succumbed to, but there is at least a risk that people will take that as requiring something less than the test that I have described.
Which is precisely the approach of the FTT to which you've just taken us.
Exactly so.
So the judge in the FTT appears to be treating the two concepts as distinct and one threshold to be lower than the other.
Exactly. That's the worry with doing that, because it imports something lesser. And the additional worry, perhaps, is that the fuel, as it were, for that potentially confusing test, genuine, affected and committed support, however you cast that, the fuel for that appears to have been the single judgment with which
the fuel appears to
the
be...
fuel for that appears to have been the single judgment of Lord Justice Sedley in Cugathas. And you'll remember that I made the suggestion that Lady Justice Arden deliberately did not agree with that.
Yeah.
She put it much more on what one would call traditional dependency.
Well, unhelpfully, she didn't actually say whether she agreed with Lord Justice Sedley. She
No,
just
she
put
didn't.
it differently.
And my Lord, we fully acknowledge that in the cases that have followed, there's been a bit of trying to apply everything and a bit of trying to marry up what may be thought to be very difficult concepts to reconcile. But I go back, if that's the position, I go back and stay with what is meant to be driving all of this and what the domestic courts are essentially trying to do, which is accurately to reflect the Strasbourg case law. And you are free to do that. You don't have to do that.
I mean, that's true, but it's not what Mobine was trying to do, or at least not expressly.
Well, Mobine, in fairness to Lady Justice Carr, I think what Mobine was trying to do was to draw principles from the line of case law domestically that had followed Cugathas without the need to go back to the Strasbourg case law. And again, in fairness to her, the clarity that one gets from some of the later case law, even if it's entirely consistent with what had gone before, if you look at it all of a piece now, was not before.
Okay, thank you.
So on the facts we submit, there's a problem with the case, with the test that's applied for the reasons I've indicated. Paragraph 1 of the FTT's judgment, you have the basic facts which aren't really in dispute, that the respondents were Palestinian residents of Gaza. They comprised a complete family unit, husband, wife, 3 children. That's the core family union. That family unit has not been broken up or interfered with in any way.
Is it 4 families, 4 children?
4 children, sorry, yes. I said 3. The focus and the way the claim is put, as I indicated earlier from paragraph 7 of the FTT decision, is on the relationship between 2 adults, the father and the sponsor/brother. And quote the... 7? Sorry, I was getting a whisper in my right ear. No, not from the court. That's the first focus. The second focus is on the degree of family life, as it's put, between the remainder of the family and the uncle, in effect, or the brother-in-law. But that's simply contingent or parasitic on the claim. It's a faintly made claim. The position on the facts as found by the FTT, go to paragraph 21. That was the position before the war or the armed conflict in Israel and Gaza broke out. The brothers hadn't seen each other in person for 17 years. For the majority of that time, any support was emotional only, no suggestion of any financial support. And he concludes in paragraph 23, therefore, that before the conflict began, there was no family life for Article 8 purposes, even applying that lower, as we submit it to be, test. Family were close, as it was put in 23, but there was not any obvious support, emotional, financial, or otherwise, between the relevant people. Since, is the conclusion in 24, the escalation of the conflict, the nature of the relationship had changed, but that had only been the position in the relatively near future, or near past, from the 7th of October attacks. appellants, it was concluded in 24, were in a profoundly dangerous situation. The sponsor was sending them £100 to £150 a month, and there was, quote, regular telephone contact with his nephews. And there is a reference in 25 to the decline in the sponsor's mental health with worry about the appellants and the wider family, which is treated as, quote, indicative of the importance of supporting the appellants through the conflict and his commitment to that support. And on the back of the facts as they appear to be, we make 5 short submissions. The first is that family life does exist between the members of the core family, mother, father and children. Nothing is done to touch, still less to interfere with that. Secondly, there is no dependence. The judge specifically so acknowledged in paragraph 25 as between the sponsor and the brother and the family, or the brother. So the only way on which family life was concluded to be applicable was on the wrong test approach as we submitted to be, but there was, in the finding of fact, no dependency. The third submission is that if you stand back from the FTT decision and apply the Strasbourg case law in relation to the relationship between, for example, the father and the sponsor / brother, and by association with the other members of the actual core family unit, there is nothing to suggest anything remotely approaching the sort of elements of dependency that sit on the right side of that Strasbourg Article 8 line, the Kumari divide. There is asserted here, you will note, no medical condition at all. And you'll bear in mind that that distinction in 38 and 39 of Kumari is dependent upon the existence of something which it might be thought would create some form of dependency, namely a medical condition requiring assistance. We haven't got any of that here. We don't even get into that sort of analysis. But fourthly, there was no contact for a very long period, no contact at all for a very long period before the conflict started. It's only from the end of 2023 that regular telephone contact started being made, and regular telephone contact is, frankly, not even close to being sufficient to satisfying the dependency test on the Strasbourg case law. If the cases that were held to fall on the wrong side of the line, involving the need for assistance because of serious medical conditions of the kind in 38 or 39, whichever one it was, of Kumari weren't enough, then this doesn't even come close. Indeed, it might be thought to fall squarely within, at most, the usual emotional ties, which are being used from the very beginning in the Strasbourg case law, from S and the UK, as being the contrast to dependency. Fifthly, financial dependence is not made out. It is at most some financial support. But even if it had been, as the Strasbourg court has made entirely clear, that would not be enough. Even dependence of that kind would not be enough. We'll have to get a bit of a wiggle on, but that's what we say about ground 1. Ground 2, whose Article 8 rights are we dealing with? Can I just give you the overview before the break for the short adjournment? The core question in relation to ground 2 is whose rights are at issue for the purposes of any proportionality analysis in this context, assuming, contrary to ground 1, that some form of family life within the meaning of Article 8.1 is established. We submit...
Is family life binary? So you say some form. Once it's established, does it matter to the proportionality analysis that it is a lesser form or a greater form? Or is it just family life?
My submission is that you are entitled in the proportionality analysis to take into account all the circumstances, and all the circumstances can include the nature of the family life involved. And so there may well be a difference in terms of the weight of justification that is required if what's being done is to, as it were, split off and separate a child from a parent as compared to the broader family outside that from the uncle. So I submit that there can be degrees. That isn't to say that family life isn't family life. It's just the circumstances. Our submission, in answer to the question that I've posed, whose rights is it, is that it is the sponsor's rights. He is the person within the United Kingdom's territory. He is the person who the United Kingdom is exercising jurisdiction over for the purposes of Article 1. And he is the person who has rights under Article 8. It is not the family members applying for entry clearance abroad. They don't themselves have Article 8 rights, and there is therefore no imposed correlative obligation on the UK in relation to them, just because they enjoy family life with someone in the UK.
Although it's pretty clear from the entry clearance cases that there may be a positive obligation to admit people, even if there isn't an interference with family life.
My lady, there may be, but that's a positive obligation which reflects and is dependent upon the person whose rights exist in the jurisdiction. If the Secretary of State is correct that the right conception of all of this is that the person who has the family rights is the sponsor, what is the significance of that? Does it matter? And we submit in summary that it's important to know whether you are concerned with justifying an interference with the sponsor's rights or with everyone's rights, every member of the family's rights. It informs what you focus on for the purposes of the proportionality analysis. It is and should be on the family life of the person with the Article 8 family life rights and the extent of interference with those that matters. So here it's the sponsor or the brother. And he, of course, is not the subject of any conditions in Gaza. The extent of interference with his rights may be, of course, we acknowledge, more serious because of concerns about the wider family that he has who are exposed to those conditions. But you're not in any sense justifying those conditions, they don't apply to him, or dealing with anything that requires or calls for removal from them because of rights. The trap, if you do not focus on the proportionality of interference with the rights holder, is that those conditions in the foreign state are in effect treated through the Article 8 backdoor as the driving feature, when we know that the front door is firmly shut, because they couldn't rely upon the conditions in the foreign state to build out or found an Article 2 or Article 3 claim. It follows that the court can consider all of the circumstances, including potentially the circumstances those out of the jurisdiction, but you need to keep the focus on the interference with the person who has the rights. So, for example, the European Court has often looked at circumstances abroad in order to test how easy or how difficult it would be for the family to move to the other country to, as it were, take the family life there. And if there would be insuperable difficulties in relation to that exercise, they take that into account. You can look at those circumstances, but it's very, very important, we submit, to keep the eye well and truly focused on whose rights and the interference with whose rights you're dealing with. And I emphasise all of these points because it's evident from the Upper Tribunal's decision 166 and following that the Upper Tribunal considered it highly relevant, that it was dealing with a situation in which it considered that the respondents themselves all have rights under Article 8, not just the sponsor. They didn't place the central focus on the sponsor's rights and the impact on his right to family life. So we submit that that is a critical feature of the case, and it's important to work out, therefore, whose rights you're dealing with.
So you say that's an area of law?
I do.
Yes.
Although that may be a convenient moment.
2 o'clock. Thank you. All rise, please.